Frank versus Westfield Insurance.
We are, Your Honor.
You're not waiting for clients or anything? Okay. All right. Then why don't we go ahead and proceed? You each have 15 minutes, and the appellant may reserve up to 5.
Thank you.
Thank you.
Thank you. Good morning, Your Honors. May it please the Court, my name is Matt Rizzi, and I represent the appellant in this matter, Lisa Frank. At this time, if it would please the Court, I would like to respectfully request 3 minutes of my allotted time for rebuttal.
That's fine. Thank you.
Your Honors, this Court should reverse the decision of the trial court below for 3 reasons. In the Westfield policy issue, bodily injury was defined to include the term loss of services. Had Westfield not defined bodily injury to include loss of services, we wouldn't be standing here today. Second, the underinsured motorist statute itself provides exclusionary language that Westfield could have included in their policy to prevent the claim that we're standing here for today. They did not include that language. Third, the policy at issue here today is an outlier policy. At the trial court level, below, the trial court was provided with more than 2 dozen, less than 3 dozen policies of other insurance companies, all of which define bodily injury to not include loss of services. Had Westfield just simply not defined bodily injury to include loss of services, we wouldn't be here today. In this case, Ms. Frank her injury is the loss of services. Her mother was killed in a car collision, and per Westfield's own definition, she suffered a loss of services, being that was her bodily injury.
Can I back you up just a little bit and then put that hornet's nest right out of the box here? The trial court found the contract to be clear and unambiguous. Is it the appellant's position that it's also clear and unambiguous, but not the way the trial court found, or that it is ambiguous? One of the two, probably both.
Your Honor, the appellant's position is that the policy clearly and unambiguously provides coverage to Ms. Frank for her loss of services claim. Where the appellant's position, Ms. Frank's position is where the trial court got it wrong is that in their order, they looked to the common and ordinary definition of bodily injury. The trial court says, we find that the policy clearly and unambiguously does not provide coverage for Ms. Frank because Ms. Frank first didn't suffer a physical injury herself. And then to rely on that, the court relied on the common and ordinary meaning of bodily injury.
And loss of services is always or is not always a derivative claim?
Loss of services is always a derivative claim. And I think where the trial court below got it wrong, Your Honor, is that the trial court was requiring Ms. Frank to first suffer a bodily injury as a condition precedent to then have a loss of services claim. Well, a loss of services claim is derivative of a physical injury to another. She can't have a loss of services claim for her own bodily injury. And I think going back to where the court, was mistaken in their analysis, is the trial court said, we look to the common and ordinary meaning of bodily injury is commonly defined as injury caused by external violence. Well, that's fine if bodily injury wasn't defined in the policy. The Ninth District is holding Fiorentino versus Lightning Rod Insurance. We only look to the common and ordinary meaning of a term in a policy if it's undefined. Well, here, Westfield took the additional step to actually define bodily injury. So when they defined bodily injury to include loss of services as a bodily injury claim, they opened the door for Ms. Frank to have a loss of services claim under the policy. When the policy actually defines a term, the policy definition controls, not the common and ordinary meaning.
Is it at all possible that the definition is relative to one section or one spot in the policy where bodily injury is defined, but not all? Because the court seems to say, looking at this policy as a whole, clearly,
Your Honor, our position is the definition of bodily injury applies to the entire policy. The trial court relied on the Supreme Court case decision of Sauer versus Cruz to say, hey, if we have any ambiguous language we're looking at, we need to look at the entire policy to determine where that language is ambiguous. And Ms. Frank would actually invite the court to follow Sauer and look at the entire policy. Ms. Frank bought a combined policy with what's called a Westpac policy. The policy provided personal auto coverage, homeowners coverage, and then underinsured motorist coverage. Now, Judge, you're asking if bodily injury applies to just the UM portion of the claim or the entire policy. At the beginning of the policy, it defines bodily injury, and the policy says these definitions apply to all portions of the policy. So bodily injury applies to the homeowners portion of the policy, the personal liability, the personal auto liability portion of the policy, and the underinsured portion of the policy. When you follow Sowers and say, let's see what the fundamental premise of defining bodily injury to include loss of services, you look at the auto portion of the policy. If Ms. Frank had gone out driving and killed someone due to her own negligence, the beneficiaries of that family would have a claim for loss of services for the bodily injury sustained by their family member. So if Westfield's going to honor derivative claims under the homeowner side of the policy for strangers of someone killed in an auto collision, or strangers of someone killed, in a premises liability side of the homeowners, then they should also honor her loss of services claim for her own injuries under the underinsured portion of the policy. This entire case could have easily been avoided by two simple steps. Westfield could have just simply chosen to not define bodily injury. If they said, we will provide coverage for bodily injury caused at the hands of an underinsured motorist, I'm not standing before the court here today. The underinsured motorist statute itself also provides an out for Westfield here. That underinsured motorist statute's been in effect since October of 2001, meaning Westfield was aware of it for at least 10, 11 years prior to the collision that brought us here today. And that statute basically states, it provides express statutory authority for an insurer to prohibit a UIM claim when the person that's actually suffering the bodily injury is not an insured under the policy. Well, that would have been Ms. Frank's mother. Ms. Frank's mother was not insured under the policy. She's the one that suffered the physical injury. Had Westfield simply included that one line in their policy as an exclusion, had that simply been an exclusion in the underinsured portion of the policy, this case would not be here before the court today. So Westfield basically had two opportunities to avoid this situation, and instead, they basically expanded the coverage of bodily injury to Ms. Frank. They could have simply chosen to not define bodily injury to include loss of services, or they could have simply put an exclusion in that says, we will not provide underinsured motorist coverage if the person that suffers physical injury, the actual physical injury, is not insured. If they put that one line in, which they have a statutory express authority to do, this case isn't in here before this court today. Notably, the trial court did not even mention Revised Code 3937-18 in their decision below. The trial court, where the trial court erred on two fronts, is that the trial court, on at least 4 occasions, found that Ms. Frank herself had to first be injured before she could then make a loss of services claim. And that's simply not what the policy says. Second, the trial court looks to the common and ordinary meaning of bodily injury when bodily injury was specifically defined. And there's case law in the 9th District, the 6th Circuit, and Barbara Bennett versus State Farm Mutual Insurance Company, and relying on interpretation of Ohio insurance contract, basically says, if a term is defined in the policy, we have to go with how the definition is in the policy, not the common and ordinary meaning of what bodily injury is. Other courts have recognized that an individual can make an underinsured motorist claim for loss of services even when they are not the individual that suffers the physical injury. If I could reference the court to American Modern Home versus Safeco Insurance Company of Illinois. It's an 11th District case. In that case, a son of a family was killed on a motorcycle. And the motorcycle was not a named vehicle on the policy. So the trial court said, because the motorcycle was not named on the policy, the person driving the motorcycle cannot make a claim for underinsured motorist coverage. The parents then tried to present a claim for underinsured motorist coverage. They weren't on the bike when the collision happened. They didn't suffer the physical injury. And the court basically said that even though the driver of the motorcycle was not named on the insurance policy, the beneficiaries of the family could still present an underinsured motorist claim for their loss of services. What's telling in that case is that in the American Modern case, in the policy, bodily injury did not include a definition of loss of services. So in that case, the 11th District allowed the beneficiaries to still make an underinsured motorist claim, even though loss of services wasn't even in the definition of bodily injury. Here, the Westfield policy does include loss of services in their definition of bodily injury. The second, Judge, going back to what you had said earlier, even if this court was to find that it wasn't clearly and unambiguous, to provide underinsured motorist coverage to Ms. Frank, a reasonable interpretation could go both ways, that the policy language at the very least is ambiguous. The policy language defines bodily injury to mean bodily harm, sickness, or disease, including required care, loss of services, and death that results. The trial court took the position that...
Okay, that results from either physical injury of the insured, or is it that results from the actions of the uninsured, underinsured?
Your Honor, I think that results could be limited to death. It says death, that results. So that results could just be limited to the portion of death. Citing the Black's Law Dictionary, Black's Law defines including as a term of both limitation and enlargement. And it actually goes on to say, when we're interpreting a statute, including can be used to enlarge. So if a reasonable interpretation of including is that it could limit, as the trial court found including to limit as a condition precedent that Ms. Frank first had to suffer a physical injury. And a reasonable alternative to that would be that if you're following the Black's Law Dictionary of including can also enlarge in addition to. So bodily injury means bodily harm, sickness, or disease, including required care, loss of services, or death that results. Those become additional standalone injuries within the definition of bodily injury. I think that an easy way to look at this would be a potential shopper looking at an advertisement for a men's clothing sale. And if the advertisement said men's clothing sale, and let's pretend that's bodily injury, and men's clothing sale is defined as shirts, pants, and shoes, including belts, ties, and wallets, a prospective shopper is not going to walk into that store and say, I have to buy a shirt in order to get a tie. They're going to look at that advertisement and say, no, I can buy a shirt, pants, or shoes, or what also is included in the men's clothing sale is a belt or tie or a wallet.
And you're in your rebuttal time.
Okay, so I realize my time has run. I would ask that this court reverse the decision of the trial court below in order that this case be remanded for further proceedings to determine Ms. Frank's damages under the policy. Thank you.
Good morning. David Utley on behalf of Westfield Insurance Company. If it pleases the court, the trial court correctly ruled that the Westfield policy clearly and unambiguously restricts claims for required care, loss of services, and death to circumstances where an insured has sustained bodily harm, sickness, or disease. The Westfield policy not only withstands a high school grammar analysis, which we laid out in our brief, but the policy language is very clear. The court did make a typo on page 7 of their opinion, noting that the required care, loss, and services and bodily harm, sickness, or disease had to be sustained by the insured, but the Westfield policy is very clear. It has to be sustained by an insured. For example,
And the other side says she not only made that typo once, but 4 times.
I didn't see it 4 times. I saw it the
We'll
one.
take a look at it. and see.
I saw it the one time, but the policy's clear. If Mrs. Frank's husband was injured, she would have a claim under the UM provision of the policy for loss of required care, loss of services, and death that results from that insured's bodily injury. The cases that the appellant cite are all circumstances where the injured party was uninsured under the policy at issue. The Jones versus Progressive case, which I handled, the Monarch case out of the 5th District, the other case out of the 6th District, all of the cases from out of state, all of those circumstances are where uninsured has sustained bodily injury.
So if Ms. Frank was in the car with her mother and aunt at the time, and Ms. Frank sustained bodily injury, and she also made this same claim for the loss of services of her mother, it would still not be covered by the policy?
It would not be covered because she was not seeking a loss of services claim arising out of bodily harm, sickness, or disease to uninsured. The policy is very clear. It's clear and unambiguous. Care, loss of services, and death all must result from bodily injury or bodily harm, sickness, or disease to uninsured. We don't have bodily harm, sickness, or disease to uninsured here. It is undisputed that Mrs. Frank's mother was not uninsured. It's also undisputed that Mrs. Franks did not sustain a bodily harm, sickness, or disease. The policy under Sowers has to be read in context. The policy has to be read in totality, but in context. In this particular case, there is no separate claim for loss of services, or separate claim for required care, or separate claim for death. You have to have bodily harm, sickness, or disease to uninsured.
But if it's unambiguous, does it still need to be read in context? I mean, I understand the nuance here, figuring out whether it's ambiguous or unambiguous, but the case law is such that you could look to other areas of the policy to get the understanding if you find that the definition is ambiguous, right?
Right,
The court here found that it's clear and unambiguous
that's right.
by the ordinary definition of words and by the contract as a whole.
Right.
So you can do all of those things in the finding of unambiguity. You must not find that it's ambiguous to resort to those other things to determine that it's what it means.
That's right. This definition was in the general provisions, or the general definitions at the beginning of the policy, and also would apply to bodily injury coverage in a liability context. The Westpac policy also has an auto provision, and if someone had a claim for bodily injury, the Westpac policy would also cover claims arising out of loss of services for bodily harm. But the UM coverage is a separate and distinct coverage in the policy. And that separate and distinct coverage restricts claims for care, loss of services, and death to those that result from bodily harm, sickness, or disease to uninsured. It's really that simple. And to attempt to twist and construe the policy is improper. The policy is clear, the policy is unambiguous, and this court should affirm the trial court's decision. Thank you.
Thank you. You still have about 2 minutes left.
Thank you, Your Honors. Your Honors, Westfield takes the position that this policy is easily understood under high school grammar analysis. I'm a proud graduate of Copley High School that I think has some of the finest English
I won't
teachers.
hold that against you since my kids are here.
Ah.
Oh, she's happy with it.
So this is,
So it's fair piano.
there we go. And I think I had some of the finest English teachers at Copley High School. And I went on to undergrad and law school, and never in my 7 years of education had I ever heard the term restrictive relative clause. And Westfield had spent a large amount of their time in their briefing trying to explain this policy by reaching to an Oxford Advanced Learners Dictionary to try to justify their position in this case in discussing restrictive relative clauses. When we're looking at restrictive relative clauses and reaching to advanced Oxford dictionaries, the policy language is problematic. Two things. Don't define bodily injury to include loss of services. We're not here. Include the UIM statute that gives you an express authority to restrict this exact type of claim. We're not here. Ms. Frank should not have to sit down and look at her policy with an Oxford Advanced Dictionary next to it to understand what type of coverages they have. Westfield chose to define the policy. Westfield has to stand behind the policy. For those reasons, Your Honors, I would ask that the court reverse the decision of the trial court below, remand this matter for further proceedings to determine Ms. Frank's damages under the underinsured portion of the statute.
Thank you.
Thank you.
Thank you to both sides. We'll take the matter under advisement, issue a written opinion, and send it to you, and also you can check on the website.
Thank you.
Thank you.
Have a good day.